everyone. My name is Beverly Allen. I'm a Tacoma-based attorney, and today I'm going to talk to you about legal separation and divorce. This video is produced in cooperation with the Pierce County Law Library and their community how-to video series. It does not reflect the views of the Law Library or of Pierce County or any of the commissioners or judges. They are solely my views based on 10 years of practicing law in Pierce County. So the difference between divorce and separation. I get this question a lot, and my advice to clients or prospective clients is you need to know what is your goal. If your goal is to separate assets and debts, to get a parenting plan if that applies, to sell property, both of these petitions, whether it's divorce or separation, can accomplish those goals, but separation can allow you or the other person potentially to have additional benefits that come from still maintaining that marital status. The most common reason why people might choose separation over divorce is to remain on the other person's insurance or to have the other person remain on their insurance. So that's typically why I see it. It's also possible that there may be personal or religious reasons why divorce does not comport with your own ethics or beliefs, but separation might be able to accomplish your objectives, to separate property and to care for the children, but without changing that marital status. So that's a possibility as well. I don't particularly recommend people filing a petition for separation if they think that's a way to keep the divorce from happening. The reason that I don't recommend that is because after that separation decree is signed, either person can go ahead and ask the court to convert the separation into a dissolution, into a divorce after 6 months. So if you're opposed to the divorce and you sign a legal separation, you've really only put off the divorce for 6 months after that decree. So it's not necessarily something to do just to keep the peace, because it can result in you being divorced whether or not you actually want to. If your contention is that the marriage is not irretrievably broken, which is our standard in Washington, then my recommendation actually is that you seek marital counseling, perhaps even during the pendency of the divorce, because it's also possible for people to agree to dismiss the case or to file what's called a notice of reconciliation. A notice of reconciliation, by the way, is something that tells the court, you know, we've filed for divorce or separation, but we're back together, we've reconciled, we'd like you to not do anything on the case. That will buy about 6 months of time before the court decides to go ahead and close that case. But the notice of reconciliation will tell the court to take no further action. Okay, so I want to show you the forms that I'm talking about when we talk about the petition for a separation and also the motion to convert that to a dissolution decree. By the way, all of these forms, you can get them at courts.wa.gov/forms. This is the website that's up on your screen now. And this is the petition for legal separation. It's very, very similar to a petition for a dissolution or a petition for divorce. Somebody has to be the petitioner. So if whoever's initiating the action or whoever had the idea in the first place, this would be the person to be the petitioner. The other person is the respondent. Again, this is a petition for legal separation. The petition for dissolution or divorce looks very, very similar. You won't have a case number until you file it. Once you do file it, the court will stamp it with the case number and assign you a case number. It's Pierce County if you are in the Pierce County limits. Otherwise, make sure you know which county you're filing into. The first part of the petition is going to be about which county everyone lives in, and that's relevant because the court needs to know whether or not it's the right court. So generally speaking, the respondent can agree to the petitioner filing it in their county, even if you're in separate counties. You are the most safe, however, in your choice if you file where the respondent lives. If there's an agreement, you can file it where the petitioner lives, or if the petitioner lives in the same county, that's fine. But if you file it where the respondent lives, then the respondent can't say that you've prejudiced them. All right, so then it's information about the marriage. By the way, you do not have to file in the county where you got married. This is a fairly common misconception. That doesn't matter because once you're living as a married couple in the state of Washington has jurisdiction over you, and the county you file in should be a convenient forum for the respondent. But the form does ask you to indicate where you were married, just for data purposes, biographical purposes. Okay, so the date of separation, and by the way, it gets a little bit confusing because separation not only refers to the legal action, the decree of separation, but it also refers to when you separated households. Washington State is a community property state. So when you separate households, the community property that you've accumulated during the marriage and the community debts, that stops on the date that you separate your households. It's a very important date. Sometimes it's contested, sometimes you can agree on it, but you need to indicate to the court what date you want them to pick. All right, jurisdiction again. Why does the court have the ability to make a decision? Is one of the spouses pregnant? There's a little bit of a legal blurb here. Washington State has presumed parentage. So if either spouse is pregnant while the dissolution or separation is pending, we're going to presume that the other parent or the other spouse is the parent of that child. If you don't have children, make sure that you let the court know that. All right. And then parenting plan, if you do have children, then under a separation or a divorce, you can ask the courts to do a parenting plan and to set child support. You can also do child support by administrative order, even without filing a case. You just need to call the State of Washington Division of Child Support. Written agreements, if you do have written agreements, indicate that to the court. Real property, let the court know how you want that divided. Personal property, also let the court know how you want that divided. The court can also divide debts and award spousal support, set a protection order and a restraining order. Basically, the court can do everything in a separation that they could do in a divorce, including changing the name. So this other document that is on your screen now, this is the motion to convert a separation into a divorce. And as I said at the beginning, if your goal is to never be divorced, don't agree to sign the separation because you've just agreed to postpone it 6 months, because either person can then go to the court and say, okay, convert this separation into a divorce. I had a case not too long ago where someone was unhappy with the property agreement that they reached in the separation. And so that person actually fought the decree from going to a decree of divorce, but there's no statutory basis for that. Whatever agreement you've signed in the separation will then become the agreement when the court converts that. So it's very important that you make sure that you are actually on board with the agreements that you're signing, because when it comes to converting the marriage from a separation to a divorce, You don't get the opportunity to argue to the court that you didn't really intend to be divorced, you were hoping you'd come back together. No, it doesn't matter at that point. The court is only looking for whether it's been 6 months since the order was signed. It's a very short motion, and that's all that it's asking. Either side can move the court to convert that from a separation to a divorce. So be very, very careful about what you're signing, and only sign agreements that you intend the court to enforce. With that, I just want to cover one other aspect that comes up occasionally, which is if you've told your employer that you're in a domestic partnership, do you have to file a decree of separation? Do you have to file a petition to get a decree of separation? And the answer is not usually. Because usually when employers are asking about domestic partnerships, they're asking about a state domestic partnership law. And in the state of Washington, you can no longer be domestically partnered unless one spouse is over 62. If you were in that period where you registered where you registered a same-gender domestic partnership, that would have been already converted to a marriage, which means that you would need to file a decree of dissolution or obtain a decree of dissolution in order to sever that originally it was a domestic partnership and then it became a marriage. So you would need to file a divorce just as every other married couple does have to do in the state of Washington. So there's no formal paperwork if the arrangement was never formal, and if both partners were opposite sex under age 62, there is no petition for separation of something that you've merely called a domestic partnership but was never actually a domestic partnership. So I got that question recently. I thought I would share that with you. If you do have any questions about separation or divorce that I haven't answered, feel free to visit my Facebook page, TacomaLegalCoach.com, and submit that question. Feel free to go to my website as well, TacomaLegalCoach.com. I do have coaching appointments, walk-in Wednesday appointments. Just go ahead and check out my website and give me a call at 253-778-6376. Again, my name is Beverly Allen, and I hope this video has been helpful to you. Please reach out if you do have any other questions.